Hey y'all, it's Kim again. So this is a 2,000 page document. Somebody like the Cernovich group or something like that, and then there's three different people. I can't remember if it was like Alan Dershowitz or somebody like that. I think it was at the very beginning. Anyway, they were basically wanting some of the Epstein court filings to be made public. And they were trying to get it sent back to a district court in order to do that. So when it says remand it back, they're trying to have them pick it back up and release certain documents for public access. Anyway, something like that. But like I said, 2,000 page document that I think went all the way to the Supreme Court to try to get this done. Anyway, but let's go on here. So this is page 31 of this particular grouping of documents. Okay, so Pooler, Circuit Judge, dissenting in part. It says, I join the court's opinion in every respect but one, the decision to unseal the summary judgment records ourselves. I agree that all or most of the material must be unsealed. Nevertheless, in my view, the district court is better suited to the task, as the court's opinion recognizes in connection with the remaining sealed materials, the district court is better positioned to communicate with the parties and any non-parties whose privacy interests might be affected by unsealing. On that score, it is worth clarifying here the breadth of the court's unsealing order. It unseals nearly 2,000 pages of material. The task of identifying and making specific redactions in such a substantial volume is perilous. The consequences of even a seemingly minor error may be grave and are irrevocable. Moreover, although I share the minority's concern about avoiding delay, I would alleviate that concern through other means, perhaps with an order directing the district court to act expeditiously and by making clear what types of limited redactions are and are not appropriate. In sum, I would unseal the district court's summary judgment decision only and leave the remainder of the materials for the district court to review, redact, and unseal on remand. So, United States District Court, Southern District of New York, Virginia L. Giuffre plaintiff versus Ghislaine Maxwell defendant. Defendant's statement of material undisputed facts pursuant to local civil rule 56.1. Laura A. Menninger, Jeffrey S. Pagliuca, Haddon, Morgan, and Foreman, PC, and then 150 East 10th Avenue, Denver, Colorado, 80203 303 831 7364, if you want to call. Pursuant to Rule 56.1 of the local civil rules of this court, defendant Ghislaine Maxwell submits this statement of the material facts as to which she contends there is no genuine issues to be tried. Ms. Maxwell expressly preserves all of her objections to the admissibility of the evidence cited herein and in the accompanying memoranda of law and does not waive any objections by making this submission numbered. Whatever this is, I don't know. So one, Ms. Maxwell's response to publications of plaintiff's false allegations, the March 2011 statement. In early 2011, plaintiff in two British tabloids interviews made numerous false and defamatory allegations against Ms. Maxwell. In the articles, plaintiff made no direct allegations that Ms. Maxwell was involved in any improper conduct with Jeffrey Epstein, who has pleaded guilty in 2007 to procuring a minor for prostitution. Nevertheless, plaintiffs suggested that Ms. Maxwell worked with Epstein and may have known about the crime for which he was convicted. In the articles, the plaintiff alleged she had sex with Prince Andrew, a well-known businessman, a well-renowned scientist, a respected liberal politician, and a foreign head of state. In response to the allegations, Miss Maxwell's British attorney, working with Mr. Gao, issued a statement on March 9, 2011, denying the various allegations about Miss Maxwell that have appeared recently in the media. These allegations are all entirely false. The statement read in full, statement on behalf of Ghislaine Maxwell by Devonshire's solicitor, PRNE, Wednesday, March 9th, 2011, Monday, March 10th, 2011. Ghislaine Maxwell denies the allegations about her that have appeared recently in the media. These allegations are all entirely false. It is unacceptable that letters sent by Ms. Maxwell's legal representatives to certain newspapers pointing out the truth and asking for the allegations to be withdrawn have simply been ignored. In the circumstances, Ms. Maxwell is now proceeding to take legal action against those newspapers. I understand newspapers need stories to sell copies. It is well known that certain newspapers live by the adage, why let the truth get in the way of a good story? However, the allegations made against me are abhorrent and entirely untrue, and I ask that they stop, said Ghislaine Maxwell. A number of newspapers have shown a complete lack of accuracy in their reporting of this story and a failure to carry out the most elementary investigation or any due diligence. I'm now taking action to clear my name, she said. Media contact Ross Gow, Acuity, Reputation, and then there's phone numbers if you want to call them. Media contact Ross Gow, Acuity, Reputation, and then an email. Okay, there's an email address. Plaintiff's gratuitous and lurid accusations in an unrelated action. In 2008, two alleged victims of Epstein brought an action under the Crime Victims' Rights Act against the United States government purporting to challenge Epstein's plea agreement. They alleged the government violated their CVRA rights by entering into the agreement. 7 years later, on December 30th, 2014, Ms. Giuffre moved to join the CVRA action, claiming she too had her rights, or CVRA rights, violated by the government. On January 1st, 2001, Ms. Giuffre filed a corrected joinder motion. The issue presented in her joinder motion was narrow. Whether she should be permitted to join the CVRA action as a party under Federal Rule of Civil Procedure 21, specifically, whether she was a known victim of Mr. Epstein and the government owed them CVRA duties. Yet the bulk of the motion consists of copious factual details that plaintiff and her co-movement, whatever that is, would prove if allowed to join. Ms. Giuffre gratuitously included provocative and lurid details of her alleged sexual activities as an alleged victim of sexual trafficking. At the time they filed a motion, Ms. Giuffre and her lawyers knew that the media had been following the Epstein criminal case and the CVRA action. While they deliberately filed a motion without disclosing Ms. Giuffre's name, claiming the need for privacy and secrecy, they made no attempt to file the motion under seal. Quite the contrary, they filed the motion publicly. As a district court noted in ruling on the joinder motion, Ms. Giuffre names several individuals and she offers details about the type of sex acts performed and where they took place. The court ruled that these lurid details are unnecessary. The factual details regarding whom and where the Jane Doe engaged in sexual activities are immaterial and impertinent, especially considering that these details involve non-parties who are not related to the respondent government. Accordingly, these unnecessary details shall be stricken. The court then struck all Ms. Giuffre's factual allegations relating to her alleged sexual activities and her allegations of misconduct by non-parties. The court said the striking of the lurid details was a sanction for Ms. Giuffre's improper inclusion of them in the motion. The district court found not only that the lurid details were unnecessary, but also that the entire joinder motion was entirely unnecessary. Ms. Giuffre and her lawyers knew the motion with all its lurid details was unnecessary because the motion itself recognized that she would be able to participate as a fact witness to achieve the same result she sought as a party. The court denied plaintiff's joinder motion. One of the non-parties Ms. Giuffre named repeatedly in the joinder motion was Ms. Maxwell. According to the lurid details Ms. Giuffre included in the motion, Ms. Maxwell personally was involved in a sexual abuse and sex trafficking scheme created by Epstein. Ms. Maxwell approached plaintiff in 1999 when plaintiff was 15 years old to recruit her into the scheme. Ms. Maxwell was one of the main women Epstein used to procure underage girls for sexual activities. Ms. Maxwell was a primary co-conspirator with Epstein in his scheme. She persuaded plaintiff to go to Epstein's mansion in a fashion very similar to the manner in which Epstein and his other co-conspirators coerced dozens of other children. At the mansion, when plaintiff began giving Epstein a massage, he and Miss Maxwell turned it into a sexual encounter. Epstein, with the assistance of Miss Maxwell, converted plaintiff into a sex slave. Plaintiff was a sex slave from about 1999 to 2002. Miss Maxwell also was a co-conspirator in Epstein's sexual abuse. Miss Maxwell appreciated the immunity she acquired under Epstein's plea agreement because the immunity protected her from prosecution for the crimes she committed in Florida. Ms. Maxwell participated in the sexual abuse of plaintiff and others. Ms. Maxwell took numerous sexually explicit pictures of underage girls involved in sexual activities, including plaintiff. She shared the photos with Epstein. As part of her role in Epstein's sexual abuse ring, Ms. Maxwell connected Epstein with powerful individuals so that Epstein could traffic plaintiff to these persons. Plaintiff was forced to have sexual relations with Prince Andrew in Miss Maxwell's apartment in London. Ms. Maxwell facilitated plaintiff's sex with Prince Andrew by acting as a madam for Epstein, and Ms. Maxwell assisted in internationally trafficking plaintiff and numerous other young girls for sexual purposes. Plaintiff was forced to watch Epstein, Miss Maxwell, and others engage in illegal sexual acts with dozens of underage girls. In this joint motion, plaintiff also alleged she was forced to have sex with Harvard Law professor Alan Dershowitz, model scout John-Luc Brunel, and many other powerful men, including numerous prominent American politicians, powerful business executives, foreign presidents, a well-known prime minister, and other world leaders. Plaintiff said, after serving for 4 years as a sex slave, she managed to escape to a foreign country and hide out from Epstein and his co-conspirators for years. Plaintiff suggested the government was part of Epstein's conspiracy when it secretly negotiated a non-prosecution agreement with Epstein, precluding federal prosecution of Epstein and his co-conspirators. The government's secrecy, plaintiff alleged, was motivated by its fear that plaintiff would raise powerful objections to the agreement that would have shed tremendous public light on Epstein and other powerful individuals. Notably, the other Jane Doe, who joined plaintiff's motion, who alleged she was sexually abused many occasions by Epstein, was unable to corroborate any of plaintiff's allegations. Also notably, in her multiple and lengthy consensual interviews with Miss Churcher 3 years earlier, plaintiff told Miss Churcher of virtually none of the details she described in the joinder motion. Miss Maxwell's response to plaintiff's lurid accusations, the January 2015 statement, as plaintiff and her lawyers expected, before district judge Mara in the CVRA, is that right? CVRA action could strike the lurid details of plaintiff's allegation in the joinder motion. Members of the media obtained copies of the motion. At Mr. Barton's direction, on January 3rd, 2015, Mr. Gow sent to numerous representatives of British media organizations an email containing a quotable statement on behalf of Miss Maxwell. The email was sent to more than 6 probably less than 30 media representatives. It was not sent to non-media representatives. Among the media representatives were Martin Robinson of the Daily Mail, P. Peachy of the Independent, Nick Summerlad of the Mirror, David Brown of the Times, and Nick Always, and Joanne Pugh of the BBC, and David Mercer of the Press Association. These representatives were selected based on the request after the joinder motion was filed for a response from Ms. Maxwell to plaintiff's allegations in the motion. The email to the media members read, "To whom it may concern, please find attached a quotable statement on behalf of Ms. Maxwell. No further communication will be provided by her on this matter. Thanks for the understanding. Best is Ross. Ross Gout, Acuity, Reputation." Jane Doe 3 is Virginia Roberts, so not a new individual. The allegations made by Victoria Roberts against Ghislaine Maxwell are untrue. The original allegations are not new and have been fully responded to and shown to be untrue. Every time this story is retold, it changes with new salacious details about public figures and world leaders, and now it is alleged by Miss Roberts that Alan Dershowitz is involved in having sexual relations with her, which he denies. Miss Roberts' claims are obvious lies and should be treated as such and not publicized as news, as they are defamatory. Ghislaine Maxwell's original response to lies and defamatory claims remains the same. Maxwell strongly denies allegations of an unsavory nature, which have appeared in the British press and elsewhere, and reserves her right to seek redress at the repetition of such old defamatory claims. Mr. Barton, who prepared the January 2015 statement, did not intend it as a traditional press release solely to disseminate information to the media, so he intentionally did not pass it through a public relations firm such as Mr. Gow's firm, Acuity Reputation. The January 2015 statement served two purposes. First, Mr. Barton intended that it mitigate the harm to Miss Maxwell's reputation from the press's republication of plaintiff's false allegations. He believed these ends could be accomplished by suggesting to the media that, among other things, they should subject plaintiff's allegations to inquiry and scrutiny. For example, he noted in the statement that plaintiff's allegations changed dramatically over time, suggesting that they are obvious lies and therefore should not be published as news. Second, Mr. Barton intended the January 2015 statement to be a shot across the bow of the media, which he believed have been unduly eager to publish plaintiff's allegations without conducting any inquiry of their own. Accordingly, in the statement, he repeatedly noted that plaintiff's allegations were defamatory. In this sense, the statement was intended as a cease and desist letter to the media recipients, letting the media recipients understand the seriousness with which Ms. Maxwell considered the publication of plaintiffs' obviously false allegations and the legal indefensibility of their own conduct. Consistent with those two purposes, Mr. Gow's email prefaced the statement with the following language: "Please find attached a quotable statement on behalf of Ms. Maxwell." Emphasis applied. The statement was intended to be a single, one-time only, comprehensive response, quoted in full, to plaintiff's December 30th, 2014 allegations that would give the media Ms. Maxwell's response. The purpose of the prefatory statement was to inform the media recipients of this intent. Plaintiff's activities to bring light to the rights of victims of sexual abuse. Plaintiff has engaged in numerous activities to bring attention to herself, to the prosecution and punishment of wealthy individuals such as Epstein, and to her claimed interest in bringing light to the rights of victims of sexual abuse. Plaintiff created an organization, Victims Refuse Silence, Inc., a Florida corporation directly related to her alleged experience as a victim of sexual abuse. The goal of Victims Refuse Silence was and continues to be to help survivors surmount the shame, silence, and intimidation typically experienced by victims of sexual abuse. Toward this end, plaintiff has dedicated her professional life to helping victims of sex trafficking. Plaintiff repeatedly has sought out media organizations to discuss her alleged experience as a victim of sexual abuse. On December 30th, 2014, plaintiff publicly filed an entirely unnecessarily joinder motion laden with unnecessary lurid details about being sexually abused as a minor victim by wealthy and famous men and being trafficked all around the world as a sex slave. The plaintiff's alleged purpose in filing the joinder motion was to vindicate her rights under the CVRA, expose a government secretly negotiated non-prosecution agreement with Epstein, and shed tremendous public light on Epstein and other powerful individuals that undermine the agreement, and support the CVRA plaintiff's request for documents that would show how Epstein used his powerful political and social connections to secure a favorable plea deal and the government's motive to aid Epstein and his co-conspirators. Plaintiff has written the manuscript of a book she has been trying to publish detailing her alleged experience as a victim of sexual abuse and of sex trafficking in Epstein's alleged sex scheme. Republication alleged by plaintiff. Plaintiff was required by interrogatory number 6 to identify any false statements attributed to Ms. Maxwell that were publicly or published globally, including within the Southern District of New York. As plaintiff alleged in paragraph 9 of the count one, of her complaint, in response, plaintiff identified the January 2015 statement and 9 instances in which various news media published portions of the January 2015 statement in news articles or broadcast stories. In none of the 9 instances was there any publication of the entire January 2015 statement. Ms. Maxwell and her agents exercised no control or authority over any media organization, including the media identified in plaintiff's response to interrogatory number 6, in connection with the media's publication of portions of the January 2015 statement. Plaintiff's defamation action against Ms. Maxwell. 8 years after Epstein's guilty plea, plaintiff brought this action, repeating many of the allegations she made in the CVRA joinder motion. The complaint alleged that the January 2015 statement contained the following deliberate falsehoods: that Giuffre's sworn allegations against Ghislaine Maxwell are untrue, that the allegations have been shown to be untrue, and that Giuffre's claims are obvious lies. Plaintiff lived independently from her parents with their fiance long before meeting Epstein or Miss Maxwell. After leaving the Growing Together drug rehabilitation facility in 1999, plaintiff moved in with the family of a fellow patient. There she met and became engaged to her friend's brother, Jason Michael Ostrich. She and Ostrich thereafter rented an apartment in the Fort Lauderdale area with another friend, and both worked at various jobs in that area. Later, they stayed briefly with plaintiff's parents in the Palm Beach, Loxahatchee, Florida area before Ostrich rented an apartment for the couple on Bent Oak Drive in Royal Palm Beach. Although plaintiff agreed to marry Ostrich, she never had any intention of doing so. Plaintiff re-enrolled in high school from June 21st, 2000 until March 7th of 2002. After finishing the 9th grade school year at Forest Hills High School on June 9th, 1999, plaintiff re-enrolled at Wellington Adult High School on June 21st, 2000. Again on August 16th, 2000, and on August 14th, 2001. On September 20th, 2001, plaintiff then enrolled at Royal Palm Beach High School. A few weeks later, on October 12th, 2001, she matriculated at Survivors Charter School. Survivors Charter School was an alternative school designed to assist students who had been unsuccessful at more traditional schools. Plaintiff remained enrolled at Survivors Charter School until March 7, 2002. She was present 56 days and absent 13 days during her time. Plaintiff never received her high school diploma or GED. Plaintiff and Figueroa went back to school together at Survivors Charter School. The school day there lasted from morning until early afternoon. During the year 2000, plaintiff worked at numerous jobs. In 2000, while living with her fiance, plaintiff held 5 different jobs at Aviculture, Breeding and Research Center, Southeast Employee Management Company, the club at Mar-a-Lago, Oasis Outsourcing, and Neiman Marcus. Her taxable earnings that year totaled nearly $9,000. Plaintiff cannot now recall either the Southeast Employee Management Company or the Oasis outsourcing jobs. Plaintiff's employment at the Mar-a-Lago Spa began in fall of 2000. Plaintiff's father, Sky Roberts, was hired as a maintenance worker at the Mar-a-Lago Club in Palm Beach, Florida, beginning on April 11, 2000. Mr. Roberts worked there year-round for approximately 3 years. After working there for a period of time, Mr. Roberts became acquainted with the head of the spa area and recommended plaintiff for a job there. Mar-a-Lago closes every Mother's Day and reopens on November 1st. Most of employees, what? I don't know what this means. Most of the employees Mar-a-Lago, I don't know what that is. Most of employees Mar-a-Lago, including all employees of the spa area, such as spa attendants, are seasonal and work only when the club is open, i.e. between November 1st and Mother's Day. Plaintiff was hired as a seasonal spa attendant to work at the Mar-a-Lago Club in the fall of 2000 after she had turned 17. Plaintiff represented herself as a masseuse for Jeffrey Epstein. While working at the Mar-a-Lago Spa and reading a library book about massage, plaintiff met Miss Maxwell. Plaintiff therefore told her father that she got a job working for Jeffrey Epstein as a masseuse. Plaintiff's father took her to Epstein's house on one occasion around that time, and Epstein came outside and introduced himself to Mr. Roberts. Plaintiff commenced employment as a traveling masseuse for Mr. Epstein. Plaintiff was excited about her job as a masseuse, about traveling with him, and about meeting famous people. Plaintiff represented that she was employed as a masseuse beginning in January of 2001. Plaintiff never mentioned Miss Maxwell to her then fiance Ostrich. Plaintiff's father never met Miss Maxwell. Plaintiff resumed her relationship with convicted felon Anthony Figueroa. In spring of 2001, while living with Ostrich, plaintiff lied to and cheated on him with her high school boyfriend, Anthony Figueroa. Plaintiff and Ostrich thereafter broke up, and Figueroa moved into the Bent Oak apartment with plaintiff. When Ostrich returned to the Bent Oak apartment to check on his pets and retrieve his belongings, Figueroa, in plaintiff's presence, punched Ostrich, I guess I say, in the face. Figueroa and plaintiff fled the scene before police arrived. Figueroa was then a convicted felon and a drug abuser on probation for possession of a controlled substance. Plaintiff freely and voluntarily contacted the police to come to her aid in 2001 and 2002, but never reported to them that she was Epstein's sex slave. In August of 2001, at age 17, While living in the same apartment, plaintiff and Figueroa hosted a party with a number of guests. During the party, according to plaintiff, someone entered plaintiff's room and stole $500 from her shirt pocket. Plaintiff contacted the police. She met and spoke with police officers regarding the incident and filed a report. She did not disclose to the officer that she was a sex slave. At a second time, in June of 2002, plaintiff contacted the police to report that her former landlord had left her belongings by the roadside and had lit her mattress on fire. Again, plaintiff met and spoke with law enforcement officers but did not complain that she was a victim of any sexual trafficking or abuse or that she was then being held as a sex slave. From August 2001 until September 2002, Epstein and Maxwell were almost entirely absent from Florida on documented travel unaccompanied by plaintiff. Flight logs maintained by Epstein's private pilot, David Rogers, evidence the substantial number of trips away from Florida that Epstein and Maxwell took, unaccompanied by a plaintiff, between August 2001 and September 2002. Rogers maintained a log of all flights on which Epstein and Maxwell traveled with him. Epstein additionally traveled with another pilot who did not keep such logs, and he also occasionally traveled via commercial flights. For substantially all of 13 months of the 72 months from November 2000, from November 2000 until September of 2002. Did I say 72 months? I meant 22 months. Sorry. My brain doesn't always work like it's supposed to. Okay. That plaintiff lived in Palm Beach and knew Epstein. Epstein was traveling outside of Florida unaccompanied by the plaintiff. During this same period of time, plaintiff was employed at various jobs, enrolled in school, and living with her boyfriend. Plaintiff and Figueroa shared a vehicle during 2001 and 2002. Plaintiff and Figueroa shared a 93 white Pontiac in 2001 and 2002. Plaintiff freely traveled around the Palm Beach area in that vehicle. In August of 2002, plaintiff acquired a Dodge Dakota pickup truck from her father. Figueroa used that vehicle in a series of crimes before and after plaintiff left for Thailand. Plaintiff held a number of jobs in 2001 and 2002. During 2001 and 2002, plaintiff was gainfully employed at several jobs. She worked as a waitress at Manino's restaurant, at TGI Fridays restaurant, aka CCI of Royal Palm Inc., and at a Roadhouse Grill. She also was employed at Courtyard Animal Hospital, aka Mark Pinkwasser DVM. That's how you say it. In September of 2002, plaintiff traveled to Thailand to receive massage training, and while there, met her future husband and eloped with him. Plaintiff traveled to Thailand in September of 2002 to receive formal training as a masseuse. Figueroa drove her to the airport. While there, she initially contacted Figueroa frequently, incurring a phone bill of $4,000. Oh my gosh. She met Robert Giuffre while in Thailand and decided, that's weird. Okay. Robert Giuffre decided to marry him. She thereafter ceased all contact with Figueroa from October 2002 until 2 days before Mr. Figueroa's deposition in this matter in May of 2016. Detective Ricari's investigation of Epstein failed to uncover any evidence that Miss Maxwell was involved in sexual abuse of minors, sexual trafficking, or possession of child pornography. Joseph Ricari served as the lead detective from the Palm Beach Police Department, charged with investigating Jeffrey Epstein. That investigation commenced in 2005. Ricari worked only on the Epstein case for an entire year. He reviewed previous officers' reports and interviews, conducted numerous interviews of witnesses and alleged victims himself, reviewed surveillance footage of the Epstein home, participated in and had knowledge of the search warrant executed on the Epstein home, and testified regarding the case before the Florida State Grand Jury against Epstein. Detective Ricari's investigation revealed that not one of the alleged Epstein victims ever mentioned Miss Maxwell's name, and she was never considered a suspect by the government. None of Epstein's alleged victims said they had seen Miss Maxwell at Epstein's house, nor said they had been recruited by her, nor paid any money by her, nor told what to wear or how to act by her. Indeed, none of Epstein's alleged victims ever reported to the government they had met or spoken to Miss Maxwell. Maxwell was not seen coming or going from the house during the law enforcement surveillance of Epstein's home. The arrest warrant did not mention Miss Maxwell, and her name was never mentioned before the grand jury. No property belonging to Maxwell, including sex toys or child pornography, was seized from Epstein's home during execution of the search warrant. Detective Ricari, when asked to describe everything that you believe you know about Ghislaine Maxwell's sexual trafficking conduct, replied, I don't. He confirmed he has no knowledge about Miss Maxwell sexually trafficking anybody. Detective Ricari also had no knowledge of plaintiff's conduct that is subject of this lawsuit. And by the way, Detective Ricari died at like the age of 50. Kind of weird. Kind of weird, I'm telling you. So anyway, I'll finish maybe these last couple. So no nude photograph of plaintiff was displayed in Epstein's home. Epstein's housekeeper, Juana Lessie, never saw any photographs of Virginia Roberts in Mr. Epstein's home or house. Detective Ricari entered Epstein's home in 2002 to install security cameras to catch a thief and did not observe any child pornography within the home, including on Epstein's desk in his office. Plaintiff intentionally destroyed her journal and dream journal regarding her memories of this case in 2013 while represented by counsel. Plaintiff drafted a journal describing individuals to whom she claims she was sexually trafficked, as well as her memories and thoughts about her experiences with Epstein. In 2013, she and her husband created a bonfire in her backyard in Florida and burned the journal together with other documents in her possession. Plaintiff also kept a dream journal regarding her thoughts and memories that she possessed in January of 2016. To date, plaintiff cannot locate the dream journal. All right, I'm going to stop it here, and then that way we can just keep going on this page. We went a little bit over, but I had to take the dog out. She's always bugging, so sometimes if it kind of pauses, it's just because I have to put pause on this and then come back to it. But anyway, I will talk to y'all later. Have a good one. Bye.